Thank you, Stephen. Good morning, ladies and gentlemen. It is indeed an honor and pleasure for me to be here today to address this distinguished forum and to be back in Prague, one of my favorite cities, as a matter of fact. I was not involved in the Intertrade case. I don't know the facts, apart from what we were told right now. So I will address strategy issues, so to speak, from a more general perspective, and perhaps wearing my arbitrator's hat more than my counsel hat. On the other hand, it is difficult to talk about strategy from an arbitrator's point of view, so I will sort of mix my aspects here a little bit. I mean, sometimes looking at it from an arbitrator's point of view, sometimes from a counsel point of view. Well, the topic is strategy. But before we talk strategy, I think we have to decide what the ultimate goal is. And we need to find a strategy to reach that goal. Well, in all cases that you are participating in, I assume that your ultimate goal is to win the case. That's what it's all about, after all. But what does it mean then to win the case? Well, it means different things, I submit, depending on the situation at hand. Ideally, winning the case means that the case is dismissed already at the jurisdictional stage. And I will come back to a few comments on that. If you don't get the case dismissed, at least you want to have the claims denied, rejected on the merits. And as a third possibility, if not even that is possible, you certainly would like to reduce the amount of compensation that the investor may be awarded. So those are the three levels of success, if you will, when you start talking about the ultimate goal, the ultimate objective, and what strategy to use to reach that objective. Well, how do you do that? How do you win the case? Well, as many of you know, and as most lawyers would tell you, it depends. It depends very much on the circumstances of the individual case. So once you are familiar enough with the facts and circumstances surrounding your particular case, you have to sit down and analyze the facts. Analyze your possibilities, analyze your options. Now, one question, perhaps of a strategic nature, is to decide, when do you do this? When do you perform this analysis? Do you wait until you have seen the statement of claim from the investor? Or do you do it already when you receive the first claim letter from the investor? Or perhaps even before you receive that letter? Well, again, I think it depends very much on the case and what your resources are. If it's a smaller case, a not so important case, maybe you don't need to spend too much time and money on that case until you have actually seen the statement of claim. And you know, in fact and in detail, what the claimant is arguing. On the other hand, if it's a big case, an important case, you're probably better off starting your analysis as quickly as possible, as quickly as you know, or when you know that there is a problem. So it depends, as I said, very much on the individual case when you actually start your analytical work. The other important aspect to remember at this stage is that your possibilities, your chances of success very much also depend on the investment protection treaty in question, on the basis of which the claimant is putting forward his claim. As you know, or many of you know, there are around 3,000 BITs, bilateral investment protection treaties, and at least one major multilateral treaty in Europe, that is to say the Energy Charter Treaty. And even though they are all similar, they are different, which means that you have to take a close look at the actual provisions of the BIT in question and try to figure out what that particular provision or what the provisions in that particular BIT actually mean for your case. analyzing and reviewing bids also mean that you have to read them, you have to analyze them against the background of the Vienna Convention, particularly with respect to the provisions on interpretation of treaties that you find in the Vienna Convention. And I will not go into the details there, but generally speaking, I think it's important to remember that interpreting treaties is different from interpreting contracts. This is sometimes overlooked, both by counsel and by arbitrators, as a matter of fact. But the rules and principles are different. So before you start working on a strategy, as I said, analyze the facts, analyze the circumstances against the background of the bid in question, together with proper analysis of the Vienna Convention and the rules of interpretation. Well, let me then say a few words about the three different stages I mentioned at the outset: the jurisdictional level, the merits level, and the quantum phase. Well, ideally, of course, you want the case to be dismissed from the very beginning for lack of jurisdiction. And in most cases, I think it makes sense for you to spend quite a lot of time on figuring out if that is indeed possible, if it's worth the time and energy to try to present arguments for the dismissal of the case. And I think it's fair to say that in most investment treaty arbitrations nowadays you have a jurisdictional phase. So in most situations there are possibilities, I think, to argue at least that the case should be dismissed because of lack of jurisdiction. And typically there are, I would say, three categories, if you will, of arguments that one should look into in analyzing the jurisdictional phase. And they all go to different provisions in the bid. All bids have definitions of investor and investment. And many of you know, are quite familiar with cases that deal with those kinds of definitions. So the first thing you should actually try to figure out is if this particular claimant does indeed qualify as an investor under the treaty in question. And I will not go into details. Other panelists will do that, and we will cover that in questions, I think. But there are a number of possible arguments that you can make as a respondent state in that respect. At the end of the day, again, it all depends on what the facts are and what the treaty actually says. But looking into the definition of investor is definitely worthwhile. Also, you should look into the definition of investment. They are different, although similar, but they are different in different bits. So again, you have to confront the facts, so to speak, of your particular case with the provisions of the applicable treaty. And I know that other panelists will deal with this more in detail. And we have seen a fair number, I would say, of investment awards where claims are being dismissed on these two grounds, i.e. either the claimant is not an investor, doesn't qualify as an investor, or the investment in question is not an investment covered by the treaty. Another jurisdictional issue which one should look into is the actual scope of the arbitration clause. I think it's fair to say that certainly as far as Europe is concerned, almost every bit has an arbitration clause providing for investor-state arbitration. But again, these clauses are different. Their scopes of application are different. So it is always, in my view, a good investment in time and money to take a closer look at the particular arbitration clause. As many of you know, some of them, mostly in older bits, are some of the arbitration clauses, that is, are limited in certain respects to issues, for example, concerning compensation for expropriation. and do not, at least not explicitly, cover expropriation issues as such, i.e., has there been an expropriation or not? There may be other variations to the arbitration clauses, but it is very often a good idea to take a closer look at the arbitration clause. But those are the three, I think, areas where you should spend time and energy in preparing your case, in preparing your strategy, with a view to having the case dismissed at the jurisdictional stage. If we move on then to the merits phase, if you can't have the case thrown out, you would certainly want to have the claims rejected or denied on the merits. And the first line of defense there, I would submit, is the question of state attribution that Dmitry Evseev will cover more in detail later on. But that is sometimes an issue which is overlooked, in my experience, by respondent states, i.e. trying to explain to the tribunal and convince the tribunal that the acts of which the claimant is now complaining are actually not acts of the state, cannot be attributed to the state. So that is the first line of defense when it comes to the merits. Now, there has been a debate from time to time whether or not attribution issues are not really jurisdictional issues. And we can continue that debate later on, but I think it's fair to say that it's not strictly jurisdiction, but a tribunal may well accept jurisdiction and then anyway dismiss or deny the case or the claims based on lack of state attribution. So that is the first important aspect you should look into. Well, when it comes to other possible arguments that could form the basis for a strategy, I mean, as you know, most investment treaty cases deal with claims for expropriation, claims for violation of fair and equitable treatment standard. And again, it boils down to, I'm repeating myself, but it boils down to the facts of the individual case. What would be your best arguments there? But some of the arguments, I think, which one should probably look into go to what we would call, or what I would call, legitimate governmental regulatory activities. I mean, this argument or these arguments are relevant with respect to both expropriation and primarily with respect to indirect expropriation, but also with respect to alleged violations of the fair and equitable treatment standard. I mean, the counter-argument from the respondent state would be that whatever happened is legitimate exercise of governmental authority, which the state is entitled to do, and therefore cannot result in any responsibility for the state. Other possible areas to look into is that of, well, let's call it legitimate expectations, which forms in a way part of both fair and equitable treatment discussions, so to speak, and discussions concerning indirect expropriation. But one could argue, for example, that the legitimate expectations of the investor could not have been anything else but, and then you go on and describe what it is, and that the investor has in fact been fully aware of the risks, so to speak, involved in this particular country with respect to that particular investment. And therefore he should not be rewarded for something which was not part of his legitimate expectations. Another argument to think about is that of, well, let's call it contributory negligence, i.e. the extent to which the investor himself has contributed to the situation that has arisen. that may also be an area where you may want to look into to find arguments to try to counterbalance what the investor is saying. And another area, of course, which has been discussed quite a lot recently or during the last couple of years is that of illegality and corruption, which are also areas, depending again on the circumstances, where you should take a close look. Needless to say, and I think we'll come back to this later in the panel, it is probably a difficult, in many cases anyway, quite difficult to prove both illegality and corruption, although by no means impossible. But even though you may not have 100% proof, it may make sense for the respondent state to put forward, I would say, civilized arguments going in that direction, because that may, at the end of the day, nevertheless have a certain impact on the thinking of the arbitrators. And moving on then to the third phase, the quantum phase. I mean, if you haven't been able to get rid of the case, so to speak, either at the jurisdictional level or at the merits level, what is left for you is to try to put forward your best case, so to speak, with respect to quantum, the ultimate objective obviously being to reduce the compensation as much as possible. And here again, it depends very much on what the actual situation is, but there are a couple of aspects that you should probably keep in mind. As we all, at least when we're talking about the typical expropriation case, the claimant will be asking for compensation for lost profits. And that is, those amounts are calculated by financial experts using very often the DCF, discounted cash flow method. As any calculation dealing with the future, because we're talking about the future, we're talking about profits that have not happened. As any calculation dealing with the future, DCF calculations are based on assumptions. And one area to focus, I would say, is to scrutinize very carefully the assumptions used by the other side's experts in putting forward his calculation. And, of course, challenge those assumptions. If the assumptions change, the calculation will change. So that's, I think, an important area to look into. Another argument that one should not forget is that of causal link. I mean, there has to be a causal link between the alleged wrongdoing and the actual damage that the investor has suffered. Obviously, if we're talking about an expropriation, which is a straightforward expropriation, the investor would typically not have a big problem showing a causal link. But the causal link argument can be very helpful when we're talking about indirect expropriation and certain violations of the fair and equitable treatment standard. Because in those cases, typically anyway, the business of the investor continues, it goes on, even though he alleges that the government has intervened in certain ways so as to reduce earnings or whatever the argument may be. But the business goes on, and it is for the investor then to try to convince the tribunal that there is a causal link between the governmental activity and the loss that he says he has suffered, which may not be an easy thing for an investor to do. Another counter-argument that is often put forward and which often makes sense is to suggest to the tribunal that the calculations suggested, or the calculations put forward, are speculative in nature, which goes pretty much back to what I just said about causal link. and assumptions, so on and so forth. But that is, of course, in my experience anyway, as an arbitrator, an argument to which most arbitrators are quite sensitive. Speculative awards are not something that arbitrators would want to issue. Finally, then, let me say just a very few words about, and now I'm putting on my arbitrator's hat, what arbitrators like and what they don't like in terms of arguments and, well, arguments that they see in briefs and arguments put forward orally by parties. Most arbitrators like to have a straightforward, honest account of the facts of the case, so that they understand what actually happened. They don't like parties to try to hide or paper over situations which may or may not be to the detriment of the parties, and that goes for both parties. So they typically are looking for and would be not necessarily impressed, but they're easier to convince a tribunal if you put forward a straightforward, chronological, typically account of the facts. And if you build your legal arguments on those facts, such that the legal arguments actually find support in the facts. Because legal arguments put forward in the abstract typically do not convince, in my experience anyway, many arbitrators. So, and try to keep it relatively simple, as simple as the case and the facts admit. Arbitrators do not like adjectives. They are not impressed by adjectives. Extremely, obviously, clearly, so on and so forth, does not impress very many arbitrators. They look for, as I said, straightforward legal arguments based on understandable facts. They do not like polemic language. Sometimes you may want to use that kind of language for other purposes, and that's fine too. But let me just tell you, it does not impress arbitrators. Another thing which arbitrators do not like is when parties try to delay the proceedings. Needless to say, there are certain situations, certain circumstances which happen, things which happen in a case which will cause a delay, and that's fine, and I think most arbitrators have no problem with that. But if they get the feeling that one of the parties is trying to delay the hearings improperly, so to speak, that will not be a good thing for the party who is trying to do that. So they would typically expect you, the parties, to behave, if I may say so, in a normal and civilized manner. That's what I was going to say. Thank you and good luck.